Hello, my name's Andrew Davis.
And my name's Alyssa Clark.
We work at the New York State Office of Indigent Legal Services in Albany, New York, and we're sorry we can't be with you today, but we're happy to be able to present to you by video instead.
We're going to talk about providing legal services in rural places and what we found in the research we did for our paper, which is an empirical examination of access to counsel for criminal defendants in rural Texas. We hope what we have to say will be useful for the conversations that you have at the symposium today. And although we can't take questions now, we'll show our contact information at the end in case you want to get in touch about anything. So today we'll talk about three things. First, we want to tell you about our experience of providing access to counsel for indigent defendants in rural places. Second, we want to tell you how we think about rurality as researchers, what it means, how we measure it, and what difference it makes. And third, we want to tell you about what we've learned during our research using data from Texas.
We work for an agency that oversees the defense of criminal defendants across New York. And although your first association with New York might be the big city, in fact, most of what we do is upstate, which is overwhelmingly rural. That means that for most of the time we work in places like this. This is a court in one of the smaller towns in western New York. In fact, what you're looking at is the entire municipal infrastructure for the town. It's dominated by a snowplow barn on the left, and on the right is a green sign indicating that these are the municipal offices, which are converted into a courtroom when court is in session. On the window, the town clerk has posted her personal cell phone number for you to call if you need her. In criminal cases, as you know, the Supreme Court has said that all criminal defendants are entitled to a lawyer. A series of cases, of which Gideon versus Wainwright is probably the most famous, says that anyone who might go to jail if convicted should have counsel appointed if they're unable to afford it. The court has also issued decisions about the minimum standards counsel should meet and how quickly defendants should be able to access counsel. To be sure, there are a lot of arguments over whether the lawyers people get are good enough or have enough resources, but you might be surprised to hear that in some places, not only are people being provided with poor counsel, they aren't being provided with counsel at all.
We looked at data from the Texas Indigent Defense Commission, which as far as we know is the only state in the country that tracks and publishes data on the percentage of criminal defendants that make use of appointed counsel. Not only that, but every one of the 254 counties in Texas has its own system for providing counsel to defendants and its own data. That means we can compare the rate at which people use appointed counsel in cities like Dallas and Houston with places like Loving County in West Texas, which in 2017 had an estimated population of 74 people.
So here's what we found. This graph shows the range in so-called appointment rates across counties in Texas. It only shows the urban counties, of which there are 82, and we'll discuss what urban means in a moment. In misdemeanor criminal cases, defendants in these counties used appointed counsel 39% of the time on average. In the other 61% of cases, defendants are either retaining lawyers at their own expense or were going without lawyers altogether. But notice something else, which is that there is a wide range in the appointment rate in these counties. Over here, there's one county where over 80% of misdemeanor defendants are using appointed counsel. And meanwhile, over here, there are 8 counties where under 10% of misdemeanor defendants are making use of appointed counsel. So, even in counties where the law about assigning counsel is the same, operating under the same constitutional requirements, the rates at which defendants actually access counsel can be very different.
But what about the rural counties? There are 172 counties across Texas that we classify as rural. Do defendants in those counties access counsel at the same rates? Well, no they don't. On average in rural counties in Texas, defendants access counsel in just 25% of cases, and in more than a quarter of rural counties, the rate is under 10%. So, misdemeanor defendants in rural counties use appointed counsel significantly less often than defendants in urban ones.
So what's happening here? Why are misdemeanor defendants accessing counsel at such different rates in rural places? Do they not want counsel? Do they not need it? Or is it just harder to get it? To answer that, we need to understand a little bit more about what actually getting appointed counsel really means. Check out this picture. This is a real door to a real public defender's office in upstate New York. It was one of several doors on a corridor, and what it says at the top is, Public Defender's Office, please come in. Then at the bottom it says, need an attorney, 2 doors down. So if you are coming to try and obtain representation by a public defender, what do? Do you come in or do you go 2 doors down? How can you be sure? The solution is that if you are not yet a client of the public defender's office but are hoping to obtain their representation, you have to go 2 doors down to fill out an application. Solving that puzzle means that you, as the defendant, are 1 step closer to receiving counsel. But then there's the application. Remember that access to counsel for criminal defendants isn't automatic. Defendants who want appointed counsel have to apply for it and show they are unable to afford it. State and local governments get to make up their own procedures for doing that. So that in New York in 2015, we documented more than 70 separate systems in place, each with a different definition of who is unable to afford counsel. Sometimes all getting counsel required was a short, informal conversation with a judge, but at other times you might be required to submit a lot of paperwork. You might be required to come for an interview during working hours, to supply supporting documentation and information on the personal finances of the people who live with you. If you don't supply the information, your application might be automatically denied, and you might lose representation if you forget to tell your attorney you moved or changed phone number. You might be assessed a fee to pay part of the cost of the public defender service. You might be threatened with prosecution if any of the information you provide is incorrect. And you might have things like child support and welfare benefits counted towards your income when your ability to pay for counsel is being calculated. Once you've done all of that, if you're found eligible, you can then follow the other instruction on the door of the public defender office and please come in.
Checking whether a person is unable to afford counsel isn't unreasonable, but it does raise the question of the extent to which governments put these kinds of rules and procedures in place as a way of containing costs by reducing the numbers of people seeking appointed counsel. Consider this story from McLennan County, Texas, about a sheriff's deputy who was assigned to check the assets of defendants applying for counsel to see if they were defrauding the system. His job was to investigate the assets of any defendant seeking counsel, including by visiting their house to inspect in person. The story says he arrested 20 people, none for fraud, but all because they were fugitives with outstanding warrants and he came across them during his house visits. Applications for counsel dropped by 40%. So state and local governments across the country have a lot of latitude in deciding what the right to counsel for criminal defendants means. They can decide how to calculate who is unable to afford a lawyer. They can decide what procedures they will use to receive and process applications. And they can decide whether they will charge defendant fees for the services they receive. Those things might help to explain why in some Texas counties almost everyone gets a lawyer, while in others almost no one does.
But what about rural areas? Is it possible that they tend to set different kinds of rules about accessing counsel than urban places? Or is there something else about rural places that just makes access to counsel harder? Well, it might be. Take this county with a large urban center in western New York. The black stars here are courts. We have a lot of local courts in New York, and in this county alone there are 40. The yellow dots, on the other hand, are the attorneys in the county who are available to take cases with indigent clients. It's a complicated picture, but hopefully you would agree that there are lawyers across much of the county who are ready to take cases if needed. Now compare this rural county. The biggest urban center in this county is a small city with fewer than 30,000 people living in it. There are 30 courts scattered across the county, but almost all the attorneys live in that one city. Attorneys are in such short supply that, as you can see, they have to call on some that live outside the county to take cases.
So being in a rural area with few attorneys might impose real obstacles to a county's ability to supply counsel to defendants. We'll explore that more in a moment. But before that, we need to talk more about what we mean when we refer to a place as rural. Earlier we talked about rural and urban counties. For that, we were using the classifications developed by the Office of Management and Budget of Metropolitan and Non-Metropolitan Counties. Here's what those look like nationally. Metropolitan counties, here in pale yellow, meet one of 2 criteria. Either they contain some urbanized area with a population above 50,000, or they contain something like a suburb, a territory that is socially and economically integrated with the urbanized core. Light green micropolitan counties, on the other hand, meet the same criteria, but the urban area is smaller, between 10,000 and 50,000 people. All other counties are called non-core and are shaded dark green. There are more detailed ways of dividing the counties up, however. These, for example, are the rural-urban continuum codes. They divide counties into 9 categories based on how close they are to urban centers, but this time they distinguish counties at several different urban population cut points, as high as 1 million and as low as 2,500. They can help to allow you to distinguish more finely between counties close to different sizes of urban centers. Then there are the urban influence codes. These break counties into 12 categories and were developed by researchers Gleffy and Parker on the theory that proximity to metropolitan economies provides an economic advantage for smaller, non-metropolitan counties. So these 3 measures all capture whether counties are close to an urban center, but there are other ways of thinking about rurality. This is the U.S. Census Bureau's urban and rural classification, and it relies solely on the populations of census tracts. Urbanized tracts have at least 50,000 people. Urban clusters have at least 2,500 people, and everywhere else is rural. Though simpler in that it relies on population alone and not proximity to an urban center, census tracts are generally much smaller areas than counties, allowing for much more refined analysis at the local level. And last, there are the frontier and remote area codes, or the FAR codes. The FAR codes work at the zip code level and reflect how remote a place is. At level 1, a place is more than 60 minutes from a town of 50,000 people. Areas at levels 2, 3, and 4 are more remote still. To be at level 4, a place must be more than 15 minutes away from even the smallest urban areas.
So, we know that access to counsel for criminal defendants is different in different places, and we know rural places in Texas seem to have lower rates of appointment of counsel than urban ones. But what is it about rural places? Is it economics? Are people just generally wealthier, meaning they don't qualify for counsel? Or is it that there are more restrictive policies in place that prevent them from obtaining it? Or is it really just something intrinsic to rural places, whether the fact that they lack lawyers or that public defense systems aren't as well developed? To find out what was really at play, we just looked at the rural counties, only those not containing or near to any urban center over 50,000 people. The same counties where an average of just 25% of misdemeanor defendants use court-appointed counsel. And we tried to answer the question, when do these counties do well? What are the characteristics of rural counties which appoint counsel at higher rates? Here's what we found. We looked at economic factors first, including the property tax base in the county and median income. We didn't find any effects. The wealth of the county government or of its residents didn't seem to make much difference to the rates of appointment of counsel. Then we looked at assignment policies, including the income levels at which defendants are judged financially eligible for counsel, the extent to which counties charge people for counsel, and popular political conservatism. We didn't find very much here either. The policies about access to counsel didn't seem to change access rates at all, though the use of appointed counsel in highly conservative counties was higher than in less conservative ones. But then, using the rural-urban continuum codes, we accounted for whether our rural counties had any small town in or near them, and separately the population density of attorneys living locally. We found significant differences. Among rural counties, having a small town was associated with misdemeanor appointment rates over 12% higher. The presence of attorneys in greater numbers was also independently associated with higher assignment rates. Then we looked at county court systems controlling for caseloads and found that places with an institutionalized defender service, like a public defender office, had 11% higher assignment rates than those with none.
So what does that all mean? First, it seems rural places do have a harder time providing counsel. Places where there are no attorneys living locally tend to have lower rates of assignment of counsel. But the presence of a small town nearby is associated with higher rates of appointed counsel regardless of the number of attorneys that live there. Perhaps small towns are places where courts and caseloads can be more easily consolidated, making access to counsel simpler.
Second, counties with institutionalized defender services appoint counsel more often. That's consistent with other research that has shown connections between how well organized the local bar is and how well institutionalized the defense function is and how effective and well-resourced defense services are.
We didn't find that policies around financial eligibility standards or recoupment of costs from defendants were associated with reduced access to counsel, but we don't think that that's the end of the story. Our own research in New York has shown that the way judges and defenders handle appointment of counsel can matter much more than written policies. With eligibility policies, we documented in our research in New York that while some judges enforce them rigorously, others go out of their way to ignore them. Another study in Florida, for example, revealed that some defendants were charged a $50 fee for defense counsel if they pled guilty at arraignment, rising to $350 if they did not. We'd need to do more research using different strategies to find out more about how the implementation of these policies in the real world acts to encourage or deter access to counsel.
But the most important lesson we think we learned in doing this research was that access to counsel in rural places may be difficult, but it isn't impossible. Washington County in our state is a largely rural county located partially inside the Adirondack State Park. In 2007, it was sued because defendants were routinely arraigned without counsel. The logistical problem of getting lawyers to the small courts around the county were considerable, but with added funding and energetic leadership at the local level, it was implemented. It's a strategy that has worked in several places and which we've documented in other work. So we think the most important implication to be drawn is that access to counsel in rural places is hard, but not impossible, when you have not only enough resources, but also local leaders with the determination to implement a thoughtful plan. Thank you very much, and get in touch.